Cornell Law School. U.C.C. Article 2A, Leases, Part 5. Default. B. Default by lessor. Paragraph 2A-516. Effect of acceptance of goods. Notice of default. Burden of establishing default after acceptance. Notice of claim or litigation to person answerable over. 1. A leasee must pay rent for any goods accepted in accordance with the lease contract, with due allowance for goods rightfully rejected or not delivered. 2. A leasee's acceptance of goods precludes rejection of the goods accepted. In the case of a finance lease, if made with knowledge of a nonconformity, acceptance cannot be revoked because of it. In any other case, if made with knowledge of a nonconformity, acceptance cannot be revoked because of it unless the acceptance was on the reasonable assumption that the nonconformity would be seasonably cured. Acceptance does not of itself impair any other remedy provided by this article or the lease agreement for nonconformity. 3. If a tender has been accepted, a. within a reasonable time after the leasee discovers or should have discovered any default, the leasee shall notify the lessor and the supplier, if any, or be barred from any remedy against the party not notified. B. Except in the case of a consumer lease, within a reasonable time after the leasee receives notice of litigation for infringement or the like. Section 2A-211. The leasee shall notify the lessor or be barred from any remedy over for liability established by the litigation. And C. The burden is on the leasee to establish any default. 4. If a leasee is sued for breach of a warranty or other obligation for which a lessor or a supplier is answerable, over the following apply. A. The leasee may give the lessor or the supplier, or both, written notice of the litigation. If the notice states that the person notified may come in and defend, and that if the person notified does not do so, that person will be bound in any action against that person by the leasee by any determination of fact common to the two litigations, then unless the person notified after seasonable receipt of the notice does come in and defend, that person is so bound. B. The lessor or the supplier may demand in writing that the leasee turn over control of the litigation including settlement if the claim is one for infringement or the like. Section 2A-211, or else be barred from any remedy over. If the demand states that the lessor or the supplier agrees to bear all expense and to satisfy any adverse judgment, then unless the leasee after seasonable receipt of the demand does turn over control, the leasee is so barred. 5. Subsections 3 and 4 apply to any obligation of a leasee to hold the lessor or the supplier harmless against infringement or the like. Section 2A-211. Paragraph 2A-517. Revocation of acceptance of goods. 1. A leasee may revoke acceptance of a lot or commercial unit whose nonconformity substantially impairs its value to the leasee if the leasee has accepted it, a. except in the case of a finance lease, on the reasonable assumption that its nonconformity would be cured and it has not been seasonably cured, or b. without discovery of the nonconformity if the lessee's acceptance was reasonably induced either by the lessor's assurances or, except in the case of a finance lease, by the difficulty of discovery before acceptance. 2. Except in the case of a finance lease that is not a consumer lease, a leasee may revoke acceptance of a lot or commercial unit if the lessor defaults under the lease contract and the default substantially impairs the value of that lot or commercial unit to the leasee. 3. If the lease agreement so provides, the leasee may revoke acceptance of a lot or commercial unit because of other defaults by the lessor. 4. Revocation of acceptance must occur within a reasonable time after the leasee discovers or should have discovered the ground for it and before any substantial change in condition of the goods which is not caused by the nonconformity. Revocation is not effective until the leasee notifies the lessor of the present value as of the same date of the total rent for the then remaining lease term of the original lease agreement, and 2. Any incidental or consequential damages, less expenses saved in consequence of the lessor's default. 3. If a lessee's cover is by lease agreement that for any reason does not qualify for treatment under subsection 2, or is by purchase or otherwise, the lessee may recover from the lessor as if the lessee had elected not to cover, and section 2A-519 governs. Paragraph 2A-519. Lessee's damages for non-delivery, repudiation, default, and breach of warranty in regard to accepted goods. 1. Except as otherwise provided with respect to damages liquidated in the lease agreement, section 2A-504, or otherwise determined pursuant to agreement of the parties, sections 102, 3, and 2A-503, if a lessee elects not to cover or a lessee elects to cover and the covers by lease agreement that for any reason does not qualify for treatment under section 2A-518, or is by purchase or otherwise, the measure of damages for non-delivery or repudiation by the lessor or for rejection or revocation of acceptance by the lessee is the present value, as of the date of the default, of the then market rent minus the present value, as of the same date of the original rent, computed for the remaining lease term of the original lease agreement, together with incidental and consequential damages, less expenses saved in consequence of the lessor's default. 2. Market rent is to be determined as of the place for tenderer, in cases of rejection after arrival or revocation of acceptance, as of the place of arrival. 3. Except as otherwise agreed, if the lessee has accepted goods and given notification, section 2A-516, 3, the measure of damages for non-conforming tender or delivery or other default by a lessor is the loss resulting in the ordinary course of events from the lessor's default as determined in any manner that is reasonable together with incidental and consequential damages, less expenses saved in consequence of the lessor's default. 4. Except as otherwise agreed, the measure of damages for breach of warranty is the present value at the time and place of acceptance of the difference between the value of the use of the goods accepted and the value if they had been as warranted for the lease term, unless special circumstances show proximate damages of a different amount, together with incidental and consequential damages, less expenses saved in consequence of the lessor's default or breach of warranty. Paragraph 2A-520. Lessee's incidental and consequential damages. 1. Incidental damages resulting from a lessor's default include expenses reasonably incurred in inspection, receipt, transportation, and care and custody of goods rightfully rejected or goods the acceptance of which is justifiably revoked. Any commercially reasonable charges, expenses or commissions in connection with effecting cover, and any other reasonable expense incident to the default. 2. Consequential damages resulting from the lessor's default include a. Any loss resulting from general or particular requirements and needs of which the lessor at the time of contracting had reason to know and which could not reasonably be prevented by cover or otherwise, and b. Injury to person or property proximately resulting from any breach of warranty. Paragraph 2A-521. Lessee's right to specific performance or REPLEVIN. 1. Specific performance may be decreed if the goods are unique or in other proper circumstances. 2. A decree for specific performance may include any terms and conditions as to payment of the rent, damages, or other relief that the court deems just. 3. A lessee has a right of REPLEVIN, detenue, sequestration, claim and delivery, or the like for goods identified to the lease contract if after reasonable effort the lessee is unable to effect cover for those goods or the circumstances reasonably indicate that the effort will be unavailing. Paragraph 2A-522. Lessee's right to goods on lessor's insolvency. 1. Subject to subsection 2, and even though the goods have not been shipped, a lessee who has paid a part or all of the rent and security for goods identified to a lease contract, section 2A-217, on making and keeping good a tender of any unpaid portion of the rent and security due under the lease contract may recover the goods identified from the lessor if the lessor becomes insolvent within 10 days after receipt of the first installment of rent and security. 2. A lessee acquires the right to recover goods identified to a lease contract only if they conform to the lease contract.